Chief Justice.
The senator from Virginia.
Mr. Chief Justice, on behalf of myself, Senator Bennet, Senator Blumenthal, and Senator Heinrich, I have a question sent to the desk for the House managers.
Thank you. The question from Senator Warner and the other senators is for the House managers. Our intelligence community and law enforcement leadership unanimously concluded Russia interfered in the 2016 election and that Russia continues those efforts toward the 2020 election. The Muller Report and the Senate Intelligence Committee reached the same conclusion. Yesterday, the President's counsel said that foreign election interference could be legal if it's related to credible information. Does this mean it is proper for the President to accept or encourage Russia, China, or other foreign countries to produce damaging intelligence or information targeting his domestic political opponents as long as he deems it to be from credible information? For the House managers.
Senators, Justice, that is the natural conclusion of what the President's lawyers are arguing. Essentially, that if the President believes that it would serve his reelection interest to seek the help of a foreign intelligence service to provide dirt on his opponent or in other ways assist his campaign, as long as he thinks his winning is in the national interest, then that's okay. It's not only okay, but no restraint can be placed upon it. Even if he were to go so far as to proclaim a quid pro quo. Hey, Russia, you've got among the best intelligence services on the planet. If you will engage those intelligence services on my behalf, I will refuse to enforce sanctions on you over your invasion of Ukraine. That may injure the security of our country, but look, I think my reelection is more important. That's where this bastardization of the Constitution leads us. The idea that no abuse of power is within the reach of the Congress. Now, I want to take this opportunity to respond to a couple other quick points, if I can. First, counsel neglects the fact that when we issued those subpoenas, we stated in the letters accompanying their issuance that they were being issued consistent with both the impeachment inquiry and our oversight authority. They neglected to tell you the latter part, that we explicitly made reference to our oversight capacity as legislators. And finally, on the issue of bribery. In the Nixon impeachment, there was an umbrella article of impeachment that listed a series of specific acts. Some of those acts involved criminal activity and some involved just unethical activity. If you accept counsel's argument, you would have said that the articles passed out of the House Judiciary Committee in Nixon were likewise infirm, because if they were going to charge the President with engaging in a criminal act, they needed to make a separate article of it. And otherwise, how dare they, would be a violation of due process to be thrown out of any court, prosecutorial misconduct, and the like. Okay, that's nonsense. On the one hand, they want to argue there's no conduct here that's even akin to a crime, when under McDonald, in fact, this would constitute bribery, withholding a White House meeting, withholding the provision of hundreds of millions of dollars in aid under the precedent of McDonald. That would be bribery. But there's no doubt it's akin to bribery. But they say unless you charge that, unless in the Nixon case they had 15 articles on each particular act, criminal and non-criminal, that you could not make out a viable charge. That's never been a constitutional principle. Just as they would have had the House organize its impeachment investigation along the terms they dictate, they now want to dictate how we can charge an offense. At the end of the day, the task is to determine whether the conduct that's charged has been committed and whether that abuse of power rises to the level warranting impeachment. But this technical legal argument that, no, you have to charge it as we would like you to charge it. That you can't make reference to the fact that, yes, these acts also constitute bribery, that that's somehow offensive to legal or constitutional principles. It's not. Yes, we could have charged bribery. We could have had 2 separate counts. That is not a constitutional requirement. And had we done that, as I said last night, they would have attacked that, saying you're taking one offense and making it into 2. That does not detract from the fact that the President's conduct violated our bribery laws, particularly as they were understood by the framers, not as they were understood 200 years later. They violated what the framers understood from British common law to constitute extortion. They violated the modern-day Impoundment Control Act. They violated the Whistleblower Protection Act. They violated multiple laws. But that's not even necessary. What is necessary is that they abuse their power. And counsel says, well, claims are made of abuse of power all the time. Yes, that's true in political rhetoric. But these circumstances warranted impeachment. The President was not impeached over climate change or any of the other innumerable examples they gave of people rhetorically saying the President is abusing his office. That's not what brought us here. What brought us here was the President decided that he could withhold military aid to an ally at war to get help in his reelection.
Thank you, Mr. Manager.